Well, the North Gauteng High Court will today hear an application to review and set aside the findings of the Seriti Commission. Civil society organizations, Corruption Watch and Right to Know say the Commission failed to conduct a routine investigation. They say the Commission arrived at the implausible conclusion there was no evidence of corruption in the 1999 multi-billion rand arms deal. The Seriti Commission of Inquiry was set up in 2011 by then Justice Minister Jeff Radebe to investigate allegations of fraud, corruption, impropriety or irregularity in the arms deal. The Commission's final report in 2016 found there was no proof of fraud or bribery in the deal. The two organizations are now challenging these findings. They argue the Commission failed to comply with its mandate by misleading the public, ignoring evidence of corruption, failing to access information from abroad and failing to investigate serious allegations of corruption and failing to investigate new information put before it. Earlier this year, the presidency said it would not oppose the application and would be willing to make submissions in court. And now for a recap on the story, we're now joined on the line by political analyst Professor Somadoda Fikeni. Dr. Fikeni, a very good morning to you. Before we get into the application to set aside the findings of the Seriti Commission, give us a bit of background on what were some of the important findings of this commission.
This commission was meant to investigate corruption around the arms deal, especially the subcontracts and what seemed to have been the kickbacks. But right from the beginning, the selection of people who were to be targeted by the commission seemed to have biases, leaving some of the most obvious. And the outcome was that there was no wrongdoing as such. And the Commission itself stated repeatedly that it was of a limited scope, which means government procuring the arms, but not necessarily focusing.
At the time.
Oh,
okay. Please go ahead.
And not necessarily focusing on the deals and the kickbacks flowing out of that particular transaction.
So at the time of the release of the report, there was a lot of unhappiness about the outcomes. What are your thoughts about these two civil society organizations now deciding to reopen this chapter?
Well, I do think that they now understand the political environment is different. There was a time when the commissions of inquiry were mainly used to manage and control the public perception. Right now, we've seen a situation where commissions of inquiry recommendations and the very nature of the commission seem to be more effective, and the recommendations leading to some consequences, as we have seen with the state-owned companies. So they might be trying to try another opportunity given this current moment of these commissions.
The challenge to the findings of the commission come at an interesting time in the life of our country where there are multiple commissions currently underway. What does this contribute to the conversation about the efficacy of commissions of inquiry?
Well, the current period, we've seen that commissions seem to be taken seriously. They are quite effective once the pronouncement has been made. Of course, they can be reviewed or challenged in court. And also, it seemed to be a way of weeding out some of the individuals fingered in corruption because politically the president and the ruling party seem to be unable to deal politically within its own ranks with such individuals. So they've decided to outsource this into the commissions of inquiry or the judiciary.
So now this challenge is coming through, and at the time when the commission was underway, another bugbear was the fact that there was just too much information that the investigators, that the commission had to deal with. But now Corruption Watch and Right to Know are contending that the Commission didn't go through sufficient information that was provided to them. Your thoughts on this?
Well, I do think that they might have a case, but not in all instances, because what we've not separated here is one thing: government's decision to procure arms, the normal process, and some individuals they might be interested in might have been involved in that particular process. So there's nothing wrong with a country at a certain stage renewing its arms and buying arms. But it seems in the process, some individuals then begin to influence procurement in terms of which company is selected, and companies in return might have given some individuals as an inducement. That's where I think most of criminality took place. But procuring arms per se may not necessarily be the issue. It could be the issue if they were purchased at a certain amount, then there's an escalation of price, which is general within the public sector. You have seen even the building of power plants and many other projects, they start at a certain level, then they increase by 400%.
Prof, what are the chances of success for this challenge, especially considering that the presidency has now come out to say they will not object it going ahead and they will give support where necessary?
Well, there might be some partial victory in a sense that if it is opened up, but at the same time, remember that some of the individuals were invited to come and present, and some of them had fingered the former President Thabo Mbeki in the cross-examination. There seemed not to be very specific information which they, as the Deputy President then, and subsequently as the President, this is how you might have corrupted the system more than to say you had taken a decision for the procurement of arms. So to that extent, it may not necessarily have the effect they want, but in terms of wanting more investigation, that may take quite some time, and also with the passage of time, as you have seen the Tale, the French companies of arms saying some of the witnesses are no longer around. It may take quite some time or even years if that is to follow the route of investigation.
Thank you very much for talking to us this morning.
Thank you.